Hi, I'm Mike Sitrick.
And I'm Sallie Hofmeister.
We're here today with Jeffrey Kessler, who is co-executive chairman of Winston Strawn. Jeff is in the New York office. Jeff co-chairs Winston's global antitrust competition practice and is the former co-chair of its sports law practice. He has served as lead counsel in some of the most complex antitrust, sports law, and IP legal cases in the country, including major jury trials, and has represented many U.S. and international companies in criminal and civil investigations in the area of antitrust, trade, and Foreign Corrupt Practices Act. He successfully defended Matsushita and JVC against claims of a worldwide conspiracy in the landmark U.S. Supreme Court case Zenith versus Matsushita. In addition to his expertise in international antitrust law, Jeff is among the country's most prominent sports litigators. In fact, Puck magazine recently said that since the 1970s, Jeff has been undeniably, quote, the most influential sports lawyer in the game, steering virtually every major labor action over that time period. In 2021, the U.S. Supreme Court unanimously affirmed Jeff's victory in the landmark antitrust challenge of the NCAA's no compensation rules brought by college players in Alston versus NCAA, calling the decision, quote, groundbreaking and disruptive, end quote. Another watershed antitrust case, McNeil versus NFL, led to the establishment of free agency in the NFL, and Brady versus NFL led to the end of the 2011 NFL lockout. Jeff also negotiated the current free agency salary cap systems in the NFL and NBA and won cases for disabled athletes, including double amputee Oscar Pistorius, that allowed them to compete against non-disabled athletes in the Olympics. In the area of gender equality, Jeff represented the members of the women's national team in soccer in their successful fight for equal pay with the men's national team. Welcome, Jeff.
Thank you, Michael.
As you know, this podcast is about the intersection of the court of law and the court of public opinion.
Jeff, you've been everywhere in the news in recent weeks because of your victory in settling the class action case you brought against the NCAA on behalf of Arizona swimming champ Grant House. He wanted to get back pay for college athletes barred from making money from their name, image, and likeness prior to the league changing its policy regarding NILs in 2021, which I know you were also responsible for as part of the case you took all the way to the Supreme Court. You've been quoted by dozens of outlets since the settlement agreement. You won the case. What was the message you wanted to get across in speaking with so many outlets? Were you, for example, setting the stage for another shoe that might drop in terms of NILs? Are you still fighting on any fronts to roll back restrictions, or was House the final chapter?
So House turned into what we believe, if not the final chapter, is getting near the conclusion, because the settlement is creating an entirely new system for the NCAA to compensate its athletes, and will resolve all of the major antitrust claims against the NCAA. So the message we were getting out there is what a landmark breakthrough this was, how it's going to transform the lives of athletes, and hopefully getting momentum behind what has to be a judicial approval of the settlement.
And can you talk about the role the media played in shaping the outcome of that case?
So the media played a role over a very long period of time. We started this fight over 10 years ago. Prior to that time, I would say many judges and many potential jurors were buying the myth of amateurism in the NCAA, and that somehow it was justified to have a system where the athletes generated all this money but didn't get any compensation for it. Over time, that image changed, and the media was important to that because it helped expose the fact that everyone in this system was making money except the athletes. You have the coaches making tens of millions of dollars. You had the athletic directors making tens of millions of dollars. You had the strength and conditioning coach in Alabama made almost $1 million. So everyone was benefiting here except these poor athletes. That message came through over time, and it made it possible for judges and juries to start taking a different view of this.
How interesting. Did you educate the reporters, or did you play any role in educating reporters over that time about this kind of disparity?
I'm sure I played a small role. It wasn't just me. There were a number of people hitting on this subject over time. Some members of the media took this issue up themselves in response to the lawsuits, saying that this really needed to change. And so it was kind of a collective movement, and I was gratified to be a small part of that movement.
And I'm sure your lawsuit laid out the narrative clearly that you wanted to project in terms of the disparity between the athletes and all the money that was flooding in for everyone else.
No question. We tried to tell a story that people can understand. The facts, frankly, were all on our side. So it was really a question of getting the facts together and putting them in a form that they would be persuasive.
Mike, in terms of the importance of the narrative, this reminds me of the Dolby case and how there was such a quick settlement after the narrative was more palatable for the media and the public at large.
That's right, Sallie. The narrative is really critical. If you're talking about the Dolby case, as you might recall, was a patent infringement matter. And when you get a complaint that is written in a very technical form, it may resonate with the judge, but it's not going to resonate necessarily with the public unless you've got an advanced degree in engineering or something like that. I got a call from the general counsel of Dolby. He was concerned that BlackBerry was the only company that hadn't signed a sound compression license for their technology. And in all honesty, after about 4 minutes into the discussion, he started getting technical, and he may as well have been speaking another language. I said, look, why don't we, instead of just filing a bare bones, dry patent infringement lawsuit, why don't we seek to enjoin the import of BlackBerries into the United States and in Germany, which is where we were filing the lawsuit. And this will put enormous pressure on BlackBerry, but it has to be written in a way that the media can understand it and that the public can understand it. And so the lawyer drafted something. We gave some suggestions on the lawsuit. We gave it exclusively to the Wall Street Journal and CNBC. And when the story broke, the CNBC person who reported it cut to the anchor, and the anchor said, well, this reminds me of a lawsuit brought by X, and they got X billions of dollars in an award for this. BlackBerry stock dropped, and by the second day, the general counsel for BlackBerry called and said, look, stop the media campaign. We will pay the licensing fees. We'll pay the back licensing fees. We'll pay the legal fees. We'll pay the PR fees. And the case, while it took a little longer to paper, settled basically in 2 days. So it demonstrates the fact that when you tell the story properly, and if you have the right case, it can have an impact. I call this putting the other side under the wheel of pain, which is making public on a broader scope what you ordinarily would just put in a lawsuit.
I'm interested, Jeff, in this myth you talk about, and NCAA creating this myth around the compensation issue. How did they reinforce that myth? How did they shape that myth? So it took you 10 years to reverse. How did they go about shaping that myth over so many years?
Well, it goes back at least to the 1920s. They started out with a premise that all sports should be amateur and that there was a purity involved and that you played for the love of the sport, not for compensation, which, by the way, was a principle that really came out of the most wealthy parts of nobility in England and didn't really translate very well to the United States of America with a diverse culture and very differences in income of the people playing those sports. But nonetheless, they perpetuated that myth and actually contended for decades that by preventing the athletes from being compensated, they are preventing them from being exploited. Over time, it became apparent that the emperor had no clothes, and that withered away as people saw that, in fact, it was totally exploitive. And part of the public communication battle here was there were so many audiences to reach, right? So you wanted to reach the judicial decision makers, but you also wanted to reach the fans of the college sports so that they would understand this and put appropriate pressure on getting this resolved. You wanted to reach members of the media who themselves had bought the myths for many years and needed to be educated about this. And in the end, when we settled, we had to penetrate all the presidents of these schools, some of whom to the very end were clinging to some of these myths until they finally realized that it was time to make a change.
And I'm sure some of the huge TV contracts also, there was an explosion in the money that was flowing into sports through television contracts. And I don't think the public had a appreciation for how large those numbers were.
Yeah, the bigger the numbers became, the easier it was to tell the story.
You clearly had to have had a lot of discussions with media, both broadcast and print and maybe even social media people. Did you?
Yeah, during the whole life cycle of the various cases, yes.
And what were the kind of things that they were asking you? And what was your goal in this? Obviously, getting your message across.
So a lot of it was responding to the arguments that the NCAA was trying to make on the other side that they were feeding to the media. So, for example, they would claim that, we can't let the athletes get paid because it will prevent them somehow from devoting time to their studies. When in fact, all the evidence was that in these big revenue sports, the teams commanded the athletes at the expense of their studies, and their support for graduation and advancing was frankly inadequate in many of these big revenue schools. So that was one of the stories. Another myth they claimed was, well, if you allowed the athletes to be compensated, you would lose the competitive parity and balance among the teams. And the answer to that was there is no competitive balance and parity among the teams. If you were Alabama, you get every big-time football recruit right now at the expense of Delaware. It doesn't make a difference how hard Delaware wants that football athletes. It's not getting a single one. And all this was doing was reallocating the money to the coaches and the athletic directors and the others in the school at the expense of these athletes. A third one, they argued, was that if the athletes in football and basketball, which are the big revenue sports, could get paid, there'd be no money for squash or for women's sports or for other sports that didn't have revenues. That was also a complete and total myth for a variety of reasons, the most important of which is the reason those schools have those sports is because they're good for the schools. So there's an entire group of college sports called Division III that has all these sports and no revenues. And why do they have them? They have them the same reason that you have the English department and the drama department and the school newspaper and everything else you have in a college, is because it is a good thing to have to attract students, to attract alumni support. So again, these were all kind of like bogeymen that they created to try to make a fear what will happen with change. And we had to get people comfortable that change was going to be positive.
I would imagine, though, that the NCAA had a substantial or significant public relations team, both inside and outside.
I suspect that they did. How effective they were in the end, you could question, but they certainly made their efforts.
Thanks, Jeff. Look, we'd like to talk now a little bit about your background, your pathway to law. Can you tell us a little bit about yourself, where you grew up, what your parents did, what you studied as an undergraduate, and then how did you decide to go into law? And specifically, you went to Columbia, if I remember reading your bio correctly.
Yes. So I grew up in Brooklyn, New York. I was the first member of my family to graduate from college. I was interested in becoming a lawyer at the time because I thought I wanted to go into politics. And I grew up in the 1960s. There was a time of a lot of political upheaval, the civil rights movement, the protests against the war in Vietnam. There were lots of women's equality. There were a lot of issues going on, and that got me interested in politics. So I wanted to go to law school. I went to Columbia College and then went to the law school. And then when I got to the law school, lo and behold, I was shocked to find that I actually liked legal issues, that I actually liked what lawyers do. And in particular at that time, I became enamored of antitrust law and decided that this was something that really interested me because it combined legal process with public policy, applying economics, changing industries for the better. And so that's what captured me. And when I graduated law school, I looked for a firm where I could practice antitrust law in New York. And I joined a firm called Manges, and that's how I got started.
And what if a young associate comes to you, or somebody comes to you, some other person comes to you and says, how can I be successful? What do you believe are the keys to success in law?
Well, first, you need to become as expert as you can in the law and the legal issues and become the best lawyer you possibly can before you get to anything else. That's just sort of the ticket to get into the theater.
And so how do they do that?
Well, again, you have to really study really hard, work very hard in law school. It's no picnic, and master the material. And hopefully you have the native intelligence and ability to do that. Beyond that, though, the next most important thing is that you are in a service business in which clients want somebody who has good judgment, who cares about you, who is responsive, who gives you a sense that they think about your problems and are not just treating you like a paycheck, and you develop a relationship with them. Those are the lawyers you go back to all the time. So there's a real element here of being a good counselor and even, frankly, becoming a friend of many of your clients if you're going to really want to work for them on a long-term basis.
Well, isn't it also being available on weekends or evenings if they call you, responding quickly?
There's no question. Your clients are people. Even if you work for companies, they're people, right? You don't work for a corporation as an entity. They are your client, but they're real people who have their own issues, their own problems.
Jeff, can you walk us through a case where the media has played a key role in shaping the opinion in favor of your client?
Sure. I think one of the best examples of that is the work I did for the women's national team in their equal pay fight in soccer. We had a very strong media outreach, public affairs outreach, and worked very hard in turning both the general public and policymakers into support for this equal pay cause for a variety of reasons. One, we knew it would be important to influence our decision makers, whether that was going to be a judge or a jury, or whether it was going to be government officials who might pass legislation in this area, but also because in the end, we thought there was a good chance that if the media and public sentiment really came in our favor, the institution itself, the United States Soccer Federation, would become enlightened and want to settle this and do the right thing. And that's exactly what happened in the end. If any people listening here watched this, you may remember we got to the point where during the World Cup in Paris in the final game, the entire stadium was chanting equal pay during our litigation that was going forward. That was no accident. That was carefully developed effort to educate the public about what's going on and build that sentiment.
And how did you do that?
Well, we worked with a very, very good communications group who developed a strategy to reach out to media and reach out to the players to do social media, which they all did as part of this. We made the athletes available and accessible for interviews because they were their own best spokespeople. They were fabulous, strong women leaders who were really articulate about why they deserved equal pay and what they were going for. And so it really was a multi-faceted campaign combined with the messages we were writing in our legal papers that put all this together. I mean, it even culminated during this litigation in a documentary that was called LFG that was made about the case. So it was lots of pieces together that brought that home.
That is fascinating. Switching gears a bit, I'm really intrigued by some of the cases of where you've represented athletes who were under great public scrutiny for their behavior. I'm thinking about ex-Ravens running back Ray Rice, who was seen on video in an elevator beating his then-fiancée and dragging her out of the elevator. I think she became unconscious at some point during this episode. Also, Latrell Sprewell, who was suspended for a year for choking his coach. When you have such public dismay over a client you're representing, how do you approach the media in those kinds of situations?
So it's difficult. As lawyers, we sometimes have to take hard cases that are controversial. Not everybody's going to love you for it. You may be attacked for it, but it's part of what our profession requires. And the two cases you mentioned were both very different and had different issues surrounding it. The Latrell Sprewell one was actually easy for me to defend publicly because that was totally misportrayed as to what happened there. That was a case where Latrell was provoked by his coach into a physical altercation, I think deliberately, where the other coaches did very little, if anything, to break it up, as the head coach encouraged the behavior, and there was no choking involved. It was a totally miscommunicated thing because the coach ended up with scratches on his neck, but it was no choking involved. If you ever saw Latrell Sprewell's hands, and if you wanted to choke somebody, we would have had a far more serious incident than what happened. And the issue there was discriminatory treatment because Latrell's discipline was multitudes higher than any discipline in the history of the NBA for behavior that frankly was far worse by others. It was never a question he should be disciplined. He agreed he should be disciplined for losing his cool and getting provoked into that. But the motivation behind that, unfortunately, was racial. It was because it was a black player who looked kind of hip hop, who got into this altercation with a white coach. And I could tell you, if it had been a white player at the time, like Chris Dudley on the Knicks, who got into this with a white coach like Jeff Van Gundy, it would have been a third of the punishment. That's what happened in that case. And in the end, the arbitrator agreed with us. And the arbitrator found exactly what we said, that it was way disproportionate. But to show you the media impact, there were calls for people. He was the dean of Fordham Law School, and there were calls for alumni to cut their contributions to Fordham Law School because this became a racially charged incident in which he sided with the black player because he thought it was the right result as a justice matter. So that was one incident. And it was tough to deal with the media because of all the racially charged issues. And people will come into that with agendas. The Ray Rice situation was, again, a very, very different situation. Ray Rice had the worst day of his life. He will tell you that. He got totally drunk and he physically struck his wife in an elevator, and it was terrible. And it had never happened before with him. They never had any history violence in their relationship at all. And it never happened again, but it was horrible and it deserved punishment. But again, what happened there, it was more the process than the incident. The commissioner first imposed a suspension, I believe it was of 2 games in the season. And then when the publicity came out, he reacted to the publicity and decided that he was going to increase the discipline much more severely. I think it was an indefinite suspension throughout the season. And I was representing the union, just as I was representing the union with Latrell Sprewell. And the union's position was that, just like the concept of double jeopardy, once you were disciplined, you don't get to get disciplined a second time. And that this was an important issue for all NFL players, not just Ray Rice, which is a lot of time you have to bring these cases to defend the rights of the individual to protect the rights of the group. And again, we had an arbitration there before a former judge named Barbara Jones, very fair adjudicator, just like Dean Fierick, who adjudicated the Latrell Sprewell arbitration. And Judge Jones found there was double discipline, and she overturned the second discipline. That was not an exoneration of Ray's behavior, and Ray would tell you that. He deserved discipline, but he also deserved to have the same treatment as everybody else in terms of that. But again, the media scrutiny there was intense, and there, because of the issue of domestic violence, which is a issue, by the way, I think is an extremely important issue, it was very hard to get people to deal with that issue on the facts and the procedures of this case, because people view it from the overall political lens of that issue. So if you are offended deeply by how victims of domestic violence are treated, you're going to be anti-Ray Rice. Now, interestingly, in that case, his wife, who was the victim there, actually stood by him extensively in that case. And it's interesting because after we won the case, and I think, Mike, you asked this question, or the question was asked, the consequences could still be terrible. He never played another game in the NFL. Even though we overturned the suspension and he was eligible to play, it became too hot an issue where teams thought if they had hired him then to play, that they would take too much backlash from groups who were against domestic violence and not look through to sort of give him a chance to rehabilitate himself. And he was out of football.
Well, there's a perfect example of how media pressure and intense media pressure influences decisions. And not only influences decisions like the one you just described, and we've seen it, but also judges are human. And certainly leading into a case, although they'll deny it, that kind of thing influences. And we've seen this, which is why it's so important to make your case. And as we say, we make it in the court of public opinion, you make it in the court of law. Let's talk a little bit about, we prepare our clients to be interviewed much the same way you prepare your clients to be deposed or testify. What do you think is key in terms of credibility?
So I think it's very important that a witness answer the questions they're asked when they're on a stand in a court of law and not try to divert or refuse to answer the question. A little bit different from media, as you know. For media training, you could frequently control the narrative and answer the question you want to answer. But when you're in a judicial setting, because the judge is going to make you answer the question, that jurors really react negatively if they think you are evading the question. That's number one. Number two, memory losses that seem inexplicable, again, is sort of viewed as an evasion by the jurors. And if you say, I don't recall, I don't remember, if it doesn't make sense to the jurors as to why you don't remember, they think that cost you your credibility. And then finally, sort of owning up to truths that may not be completely helpful to you, but owning up to them and explaining them as best you can, but not denying them, I think is very important for the credibility of a witness.
Well, that brings us to one of my favorite topics, which is comment or no comment when you get a call from the media. I would say a very large percentage of people in my business and a very large percentage of people in your business, meaning law, default to no comment. From the media standpoint, it's guilty as charged. And in my book, I say, well, I understand, my last book, I understand why there are times you can't comment. Generally, it's PR malpractice. What's your feeling in a situation like us? We always say, find out what the questions are, then make a decision. There's nobody who has to order you. What's your feeling on that?
I, in general, agree with you completely. I think lawyers can be much too conservative about this. The media is going to write the story anyway. And I think finding a way to get your message across, your point of view, your side of the story is extremely important. And it can be done a variety of ways. You could go on the record or not on the record. You could do it on background. You could get another spokesperson to speak if for some reason you shouldn't speak. There are a lot of times I don't want my client to directly speak, but I might speak, or I might get somebody else to get the message out. But I think just ignoring it and letting the media run with somebody else's message is often not a well thought out strategy.
There's an editor who's retired now who used to say, he was a combat veteran, he loves when people say no comment to him because they're in the free fire zone from his perspective. He can basically write anything he wants. Let's talk about a situation where your client is demonized in a filing with very serious allegations. And the media picks it up because many of your clients, like many of our clients, are very high profile. There are some lawyers who will just, in a response, put deny, a basic response. And they'll say, well, we're going to settle it. And we tell them, that's great, but everybody's going to think you're guilty because there's no specifics of deny. And they look at a settlement as an admission of guilt. We advocate, wherever possible, be specific in the denials and refute the allegations. What's your take on that?
I think if you have a story that you can tell, which is the same story you're going to tell in either the court or the arbitration or wherever it is, that explaining that story to the public will help. So there's no reason not to be more specific in the denials. Of course, there are some situations where you don't really have a good story to tell, and the specifics may not be helpful, and that might lead to a different PR decision. But if you really can explain yourself and put yourself in a better light, then I agree. It makes sense to get that word out there.
Or if there are errors in the complaint, at least instead of saying I'm not commenting on the complaint, you can say the complaint is replete with inaccuracies. We'll be more specific when we...
Or you could point out some, if they're there. Again, if the facts are helpful, there's not a lot of downside in getting those facts out. Now, sometimes there could be a strategic reason in a case where you want to surprise the other side that they don't know their facts are wrong. And so maybe you need to withhold that for a while. So I could see that obviously all decisions are case specific, right? So it's hard to give general advice, but if you can tell a story and it's not going to prejudice you in the case in terms of your strategy, I think it makes sense to get your message out.
Likewise, when there's an error in reporting, we almost always recommend, even if you don't want a correction, going back to the reporter and pointing out the error.
Well, especially today, because in the world of social media and the internet, when you get one erroneous statement, that can live for years because lazy journalists go back and just find a prior story and repeat it, whether they have a source for it or not. Their source is the previous story, which is erroneous. So yes, there is great benefit to correcting facts that are really harmful and not just letting them sit out there.
And as you probably know, with one of your partners, we have had situations where anonymous sources were being used over a long period of time, or a reporter has been unfair. In addition to writing, we've called for a meeting with top editors, the editor and the reporter. Is that something that you do if it's serious enough?
I've never had to be in that situation, but I certainly could see where if something got severe enough that it might be required.
Are there any cases you can talk specifically about in terms of when, the question Mike asked about being demonized and the various, if this, then that, if...
So I represented the union and Tom Brady in Deflate-Gate. And there were a ton of false media stories about how the ball was tested and what those test results showed. There were a lot of Tom Brady haters out there. There were a lot of New England Patriot haters out there. By the way, a lot of New England Patriot fans who were on the other side, so it's very divided. But getting the actual facts out about what the testing really showed and how it was done, which actually didn't really scientifically show any deflation at all, was a real effort to try to get that word out. And again, it was done a whole variety of different ways. Some of it was interviews. The Patriots themselves actually created a whole truth website, I think, that they set up to get the real facts out there because there was so much misinformation going on. And to this day, like a lot of polarized issues, because sports fandom could be polarizing, just like politics could be polarizing. There are some people who will believe some facts where they read somewhere, even though they are demonstrably false about that. And there's just nothing you could do to convince them.
We've done the truth websites as well.
Right.
And sometimes it gets serious enough because we control access. And quite frankly, when we break a story, have such big stories to break, we'll get the editor-in-chief involved in this and have them in the stories in these meetings as well. And it's been very effective.
Yeah, the biggest thing in the Brady case was, so they reported that the balls were of a lower inflation than the rule required, which is true. And what they ignored is that the NFL didn't know how to test under what's called the natural gas law, which is that in cold weather, balls deflate. So you had to adjust your measurements to account for the fact that it was a cold, wet day that was deflating the balls, and that when you actually did that adjustment, there was virtually no deflation.
Nuance.
Right?
Nuance.
But you couldn't get that out. And the reason was because the NFL, this is another fact, never tests balls, even though they had a rule. So the people who were doing it were literally testing them for the first time because the other team had complained and they had no idea what they were doing. And those were the facts regarding that.
So I love this story because it does, for purposes of illustration, help define how you deal with the media. There were a ton of stories out there that were incorrect. Did you go try to correct all those for the record? Because, those will be picked up in the future.
Well, we did as best as we could. We tried to talk to select influential people in the sports media to get them to sort of carry the message because there were too many outlets to try to go out and correct the original stories. And then the Patriots did some other stuff on their own in terms of that, as I said. But we developed a strategy of finding trusted messengers who everywhere, and not like messages being like the beat reporters for the Patriots, because no one would believe them because they say, oh, you're just a Patriots bias reporter. We found trusted national reporters who were respected for their fact finding and tried to give them the facts to get an accurate or more accurate story.
Mike calls that the lead steer philosophy.
Yeah, the media has very much a herd mentality. And like any herd, they follow a lead steer. That can be the New York Times or 60 Minutes, or it can be a well-known reporter such as Jim Stewart at the New York Times, or Bill Cohn, who's now writing for Puck and Airmail, or Andrew Ross Sorkin. It can be, a number of people like that. Let's talk for a minute about social media, because Gen Z and millennials they live on social media.
Well, sports fans too.
Well, that's right. But especially that group, right? And I assume there are times that you tell your clients, stay off social media, at least on topic A, B, and C.
Sure. Well, there's some things we don't want the client talking about, right? In the case, we don't want them talking about our case strategy. There's confidential things, a lot of things we don't want them talking about. And we also, on social media, if you're going to use it about a case, we want to know what the message is. And we review the message and say, okay, this is a message you should get out. Don't ad lib. Don't go into areas because you're not going to understand the case implications or the nuances. So a lot of it is getting out the right message. But if you have famous and influential clients who have a big social media following, it actually can be very effective. As I said, social media work that the women's national team members did was instrumental to shaping that narrative because they had very, very large numbers of followers who would then also echo and move that message throughout social media.
As long as you can control them.
That's correct. And they were very disciplined.
So tell me, you've had so many high-profile cases and so many victories. If you had to pick one case, I know this is going to be difficult, that was in your top 5 that you're most proud of, what case would it be?
So that's really hard. It's like my 4 grandchildren keep asking me which one is my favorite. And I tell them, that I love them all equally. I have no favorites. So that's like what it comes down to with some of my cases. So I'm going to be obstinate like I am with my grandchildren and give you a couple.
That's fine.
Not one. So the ones that have been most impactful, which is how I can judge it here, have really been the college sports settlement that we're doing now, because that's going to change lives, and also involved as its predecessor, a 9-0 Supreme Court victory, which was the only time I argued in the Supreme Court, and that was very meaningful to me. That's one. The second is going to be the women's national equal pay thing, because that had so much influence outside of women's sport and the fight for equal pay more generally. And the third would be the Freeman McNeil free agency trial, because that sort of set the stage for the whole free agency salary cap system in the NFL and changed a lot of lives there. It was influential in other sports as well. So those are 3 I'd probably pick as being among the most meaningful.
Thank you. We appreciate your taking the time, Jeff. And this is Mike Sitrick.
And Sallie Hofmeister.
And this is the intersection of the court of law and the court of public opinion. Thank you for listening. You've been listening to the intersection of the court of law and the court of public opinion with Mike Sitrick and Sallie Hofmeister. This is a production of Sitrick & Company. To send your questions, hear clips from the show, and learn more about us, follow Sitrick & Company on LinkedIn and visit our website, theintersectionpodcast.com. That's theintersectionpodcast.com. Be sure to follow us on your favorite podcast streaming platform. And if you like what you hear, please leave us a comment or review. Once again, thank you for listening.